Broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone, and welcome to today's MCMA January webinar. Today, we're going to talk about the GDPR, and we've got a great set of hosts here. We've got Eric Shanfelt, and we've got Andrew also with us today, and they're going to run us through the GDPR. If you have any questions, make sure you use the chat tab. If you have any problems, please let me know as well using that chat tab. If you have questions for Eric or Andrew, make sure to drop in those questions into the questions tab on your right-hand side where you have the GoToWebinar control panel. Once again, we'll get started right at noon and welcome everybody to MCMA's January webinar. Thanks so much. Good afternoon, everyone, and welcome to MCMA's January webinar. We're going to get started here in just a couple minutes. Just want to run through some housekeeping things with everyone and make sure that everyone can hear me. And today we're gonna run over the EU's General Data Protection Regulation. We've got two great panelists here. We've got Eric Shanfelt and Andrew Smith with us today. And if you have any questions during the presentation, use the questions tab down at the bottom of your control panel. And if you're having any issues, you can also use the chat and let me know so that way we can get those issues fixed up. Once again, we're going to get going here right in about 4 minutes. And thank you so much for everybody for joining us today. Good afternoon, everyone, and welcome to MCMA's January webinar. Today we're going to talk over the EU's General Data Protection Regulation. We're going to get started here in about 1 or 2 minutes. If you guys are running into any issues, if you can't hear me or you're having problems with the slides, just reach out and let me know so that way we can get that fixed. Once again, we're going to start here in just about 1 or 2 minutes. Today we've got two great panelists. We've got Eric Shanfelt and Andrew Smith, who are going to walk us through the new regulations with the GDPR. Once again, we'll get started here in just a minute. If you're having any issues, let me know. You can use the chat or you can use the questions tab as well. So once again, we'll get started here in just a second. Thank you, everyone, for coming, and we'll start shortly. Thank you. Good afternoon, everyone, and welcome to MCMA's January webinar. Today, we're going to talk about the GDPR, and we've got two great panelists. We've got Eric Shanfelt, and we've got Andrew Smith. But before we get started with today's webinar, we're going to go over a couple housekeeping tasks and whatnot. And first, once again, thank you, everyone, for attending. Wanted to just touch on a few things before we get started. Wanted to let everybody know that the MCMA website is a great place to see upcoming events and get a lot of information as well. You can view our sponsors and upcoming events. And we cannot do this without our sponsors. So thank you so much to all of our sponsors. Once again, we could not do any of this without you. So thank you so much. And we really appreciate all your support. And we have some really great upcoming events. So make sure to check out our events calendar. The 2018 events calendar is up on the website. So make sure you go and check that out. And as we move into today's webinar, if you have any technical issues, make sure to reach out to me so that way I can help you out with that. And I guess I should introduce myself. I'm Tim Barry. I'm going to be moderating today's webinar. So if you do have any issues, reach out and say, hey, Tim, having a couple issues here, and we can get that fixed for you. If you have any questions throughout the webinar, make sure to use the questions tab down there on the right-hand side of your control panel. And what we'll do is we'll take those questions in, and then we'll review those at the end of the webinar. So without further ado, let's get started. Today, we're going to talk about the EU's General Data Protection Regulation, the GDPR. It goes into effect May 25th, 2018, and it will affect you. On today's webinar, our experts will help us understand what the GDPR is and what it is not. Today's session will also touch on what you must do to comply and how it impacts your privacy tracking in other systems, such as email and circulations. There are three things that make the GDPR worth your time. 1, it's a set of regulations, not recommendations. It's not optional. 2, it is issued by the EU, but it affects U.S. entities. 3, it's got teeth, penalties, and judicial stature, and that involves consumer consent. We are fortunate that today's webinar will be guided by Eric Shanfelt with eMedia Strategist and Andrew Smith with PrivacyCheq. Eric is a sought-after digital strategist, author, speaker, and consultant working with B2B consumer companies to build their digital platforms, audiences, and revenues. Andrew is an instructor and technologist working to help organizations install privacy-enhancing technologies. And with that, I'm pleased to introduce Eric to the webinar. Thank you so much, Eric.
Thanks, Tim. Appreciate it. And then we're just swap the screen over here to my screen, I think, correct?
Yes, we are. So give me 1 second and we'll get that right over to you.
No problem. No problem. Appreciate it. Well, like everyone else there, we're finally starting to warm up here a little bit. I live out in Colorado, and we've had sub-zero temperatures the past couple mornings, but I guess back there in the east, it's been even worse. So no problem. There we go.
No, all right.
All right. Hopefully everybody can see my screen. Again, just thought we'd just introduce ourselves real quick. I'm Eric Shanfelt. I'm the principal of eMedia Strategist, and really I've been in the digital media marketing space for over 25 years now, working for companies like Penton and F&W and HarperCollins, and now I help other companies with their digital strategies. My contact information is there. Andrew, you want to introduce yourself?
Yeah, absolutely. And I see the screen, Eric. We're all good to go there. I work here at PrivacyCheq, and we write privacy-enhancing software to help build an organization's digital trust. And so I deal with kind of strategies of complying with the GDPR, not only technologies, but also processes, employee policies and procedures that you might want to go through. Unfortunately, I know nothing about marketing, but I'm here to kind of lend a hand with respect to the general data protection regulation.
And so I met Andrew a few months ago, and he and I have been tag teaming on some stuff with GDPR as it relates to media companies and publishers. And so that's what we're going to dive into here. So I have to do the obligatory disclaimer here that we are not your lawyers. We are not attorneys. I didn't say the Holiday Express last night, but I did a couple nights ago when I was traveling. So we just want to let you guys know that we're going to give you our perspectives on this from both from technical and from a media perspective, and what we see is happening down the road. But please, this is a legal issue. Make sure that you consult with your own legal counsel about your specific situations. So with that disclaimer out of the way here, let's just dive in a little bit here. So we already covered what is GDPR. Let's just go over it real quickly. Again, it's the European Union's General Data Protection Regulation. It's just a set of consumer protection laws. I think what's important to note here, though, is there have been anti-spam laws in the past. There have been other things, CAN spam in the U.S., the Canadian anti-spam law, CASL up in Canada. This is going way beyond this. This is really talking about general data protection for individuals in the EU. By the way, I do want to let you know this does also include the UK. Brexit isn't official yet, but even after Brexit becomes official, Andrew and I were talking yesterday. You said, look, hey, the UK wants to do business with the EU. They're going to have to comply as well.
Just as much for us Americans doing business in the EU, exactly.
Yeah, exactly, the same thing. And so the penalties, I don't want to go into all the details of the penalties, just to let you know that, hey, if you're found to not be compliant with GDPR, penalties can go up to 4% of a company's annual revenue. So some pretty good teeth in the regulation. And yeah, May 25th, that's 4 months away.
Yeah, actually, if I could talk to that, the law is actually in effect right now. They're just holding off enforcement until May 25th. So as far as we know, these supervisory authorities are already looking at your procedures, your websites, your mobile apps, and maybe even queuing up enforcements as we speak.
That's a great point. That's a really great point. Yeah. So bottom line, it's here. It's reality. But then we have to ask. Okay, we most of us here maybe not be international. Some may be international. I mean, certainly, if you have an office or a headquarters somewhere in the EU, this definitely applies to you. But for most of us who are U.S.-based companies, we got to answer the "who cares" question. Why does this matter? And I think that the biggest issue here is unlike previous situations, there's some new frameworks and regulations coming up here right now. There's the US Privacy Shield framework, and there's also something called the Judicial Redress Act. Now, again, I am not an attorney. It's getting a little bit out of my pay grade, but what I do know this means is that U.S. companies with these, and the discussions with the GDPR, means that U.S. companies could be subject to a legal action out of the EU related to GDPR, whether it's governmental action, whether it's companies, or whether it's even individual class action suits, that there is now the opportunity for U.S. companies to be subject to those regulations. So bottom line, you don't want to ignore GDPR. This is the big question. So ask yourself, do you have any European customers or subscribers? Do you have any European email subscribers or website visitors or European app users? You can't tell if they're European email subscribers just off of the email address that they're using. European individuals can use Gmail addresses, for example. IP addresses don't always show you the geographic location of a website visitor. So the answer is that you probably do have this, and I'd say more than likely you do, and that the fact that GDPR does apply to you. So that's unless you're going to completely ban all European traffic and measure for that and intercept that and ask people where they're from constantly, you're going to have some European visitors to your site. We're already dealing with this to effect with Castle, right? Castle came out, and it's the Canadian anti-spam law, and we don't know if an email address is from Castle or not, so we have to kind of be compliant with that.
Right. That is a strategy that you could ask your customers where they're from and branch based on that. The fact that they say that they're from a certain place, that is one way to tell.
Right. So, I mean, hey, if worst comes to worst, you can always, intercept that. But that becomes obviously like a big problem for media companies. You don't want to always ask somebody where they're from. But if you want to do that, if you want to branch logic, that does say this person said they are not from the EU. I have to trust what they say, and that can count. I think it's important, though, for us to not overreact, and let's talk about what is the risk for publishers really. And I had a really good the legal counsel at HarperCollins I had worked with. He was fantastic, and one of the things he said to me once is I was asking, well, how can we eliminate the risk from this particular digital venture we were looking to do? He said, well, if you want to eliminate risk entirely, just don't do business. No matter what, there is going to be some risk, and you have to determine with your own company and with your legal counsel what level of risk are you comfortable with. I mean, if we take a look at the existing laws, CAN-SPAM, Castle, the Children's Online Protection and Privacy Act, COPPA, the ramifications have been minimal to at least this point. Yes, there have been some high-profile lawsuits that have come out. I was even at one of the companies I worked with. We got sued under CAN-SPAM. Good news is we were completely compliant, but we still wound up having to settle out of court. There's not been a lot of enforcement of these laws, and there may or may not be a lot of enforcement of GDPR. The problem is, though, we don't know, and that could change overnight. So you have to determine the level of risk that you're comfortable with. Do you have any thoughts on that one, Andrew?
I was going to throw in that, of course, VTech was recently prosecuted under COPPA from the Federal Trade Commission here on the 8th, and that fee did not come out to be very much. It was only $650,000 over, which turned out to be 6 cents a kid or something. I'm totally doing this off my head, so I'm sure I'm wrong on those figures. But you're absolutely right. The risk, we don't know what it's going to be, but there is in fact a risk, and that's why we're sharing this information with you.
Yep, and certainly, of course, the bigger companies are going to be the bigger targets. They're going to go after the big boys out there, the Googles, Facebooks, Apples, Amazons, Microsofts, you name it. The large media companies, the News Corps, the $3 billion, multi-billion dollar companies, Hearsts and Formas. The really big companies out there will probably be a bigger target. Interestingly, though, I work with a couple of my clients in the B2B space, B2B publishers, who have already had some RFPs come in from their advertisers who are asking, are they compliant with GDPR? Is the media company going to be compliant with GDPR? And if not, then they would not run advertising with them. So even if there's not a legal risk, there is the potential, especially if you do a lot of risk with international advertisers, of that question coming up in the RFPs, and it perhaps impacting some of your revenue opportunities. Yeah, let me talk about, what about small regional publishers? Providence Business News, Boca Raton Magazine, 5280 here in Denver, things like that. Again, those are going to be probably at the lower end of the risk spectrum. So again, you have to talk to yourself and to your own legal counsel and determine, well, what level of risk are we comfortable with or not? And we'll get in a little more here in some of the ways to comply with this. But again, just want to be clear here. I don't want to, there's a lot of talk about this and that the sky is falling. And, so far there hasn't been a lot of stuff going on, but that could always change in the future. I do want to talk a little bit about the kind of information that GDPR is going to be covering, and the term PII, which is personally identifiable information. So that's anything I can tie back to you as an individual: your name, your email, your physical address, phone, demographics, purchase data that's tied back specifically to you. Anything that can be tied back to you as an individual, health information, any of that is personally identifiable information. Now, GDPR primarily addresses PII, personally identifiable information. However, there is this wonderful EU e-privacy directive. Yes, another regulation that is out there right now that and Andrew, I'm going to turn this over to you here in a second, but in general, it could add non-personally identifiable information included underneath the regulations of GDPR in essence. So things like cookies, digital fingerprinting, where you can identify someone by the device parameters that they have. Those are now going to also fall underneath as personal information in the regulations. So all this is going to come in. You already see this a little bit on the UK PECR regulation, Privacy Electronic Communication. If you've gone out to, let me bring up a web browser window here real quick. And for instance, if you go to Irish Times in the UK, you've seen this, I'm sure, on a lot of sites. Let's see if it comes up. It's going to come up. Of course, it won't come up for me. But you see that this cookies, yes, we will accept you have to click here to accept cookies.
You may have already accepted them, actually. Ironically, is what might have happened there.
Yeah, you're right. I probably already did. Let me get up a new incognito window.
Yeah, that might do it.
There we go. There it is. So when you first come to the site, that's a giant ad. When you first come to the site, you have to consent. You're saying you consent to the use of cookies, right? This is the UK's Privacy Electronic Communications regulation. So we may see something like this coming to play in the GDPR regulations.
Or in the e-privacy regulation, you mean, right?
Correct. The e-privacy directive is coming online. So they're trying to implement it at the same time as GDPR. So in May. Bottom line, whether it happens there then or not, it's likely to come soon thereafter. So when we're talking about what are the information, it's not just personally identifiable information. It's also non-PII. It's going to be
any electronic data is the way actually that particular regulation reads, which is really sticky. But as you say here, it's not likely to happen. I even just read an article today that said it might be as late as 2020. So
right.
Hopefully that's good news. right?
So yeah, right now for May, we're talking about GDPR, which is really dealing with personally identifiable information only, but be aware, there's more stuff coming down the pipeline that could begin to include non-personally identifiable information, okay? All right, one more thing I want to just talk about, personally identifiable information. As a publisher, this isn't just email. You got to think about everywhere that you are asking for personally identifiable information, right? So website registration, whether you're using WordPress registration or Drupal, maybe using a cloud-based system like e-publishing or something like that. When you register with your website, you are collecting personally identifiable information. You got to think about that. Landing page builders. A lot of us use landing pages to this, ClickFunnels, Unbounce, lead pages, those kinds of things. We're collecting personally identifiable information there. So that's part of your user database, kind of contains all these pieces. Circulation systems, whether it's a software system that you have on your own servers, or whether it's something like an outsourced to eMedia or Palm Coast Data or CDS, that's included as part of the personal data you have about someone. Of course, your email systems, your Gmail, Silverpops, Exact Targets, Active Campaigns, Constant Contacts, unified audience databases or consumer data platforms like HubSpot, BlueConic, Knowledge Marketing, Salesforce. That's you're collecting data there too. We oftentimes run contests, Rafflecopter, ShortStack, WooBox, things like that. You're collecting personally identifiable data there. Surveys you may run through Qualtrics or SurveyMonkey. Commenting is an interesting thing, right? You've got the Discuss system, which is a third-party system, Facebook comments. If you're collecting comments through your own CMS, like with WordPress or Drupal or things like that. You also think about any e-commerce systems, WooCommerce, if you're running a WordPress site, or Shopify or Magento. There's more beyond this. The idea is just you really want to identify where are all the places where we are collecting data on an individual, because all of that is going to fall into where you need to get consent and how we need to manage that customer data. So I wanted to give you guys a thought to begin to think, make sure you're thinking about all these different places, because it's not just your email system or your unified audience database. You've got customer data in all of these places. So Andrew, I'm going to turn it over to you and let you kind of walk us through kind of all the GDPR lifecycle and the rights.
Yeah, but this is kind of a discussion of how to think about your customers' data as it is captured by your websites or your apps. You're going to want to be able to provide a notice here at 12 o'clock. Of course, a privacy notice could be as simple as what you've got on your website already about your policies for how you deal with personal data that comes into your system. But you could consider creating something that's a little more lightweight, something layered, which we can talk about as well, where maybe the first layer is maybe a single sentence going all the way down to maybe a graphical notice with iconography, and then only showing a fully fleshed out legal document if a particular customer really wants to know what is going to happen to their personal data. Then if we can continue to 3 o'clock, of course, you're going to need to collect a customer's consent. I might say a data subject. Of course, data subject is how the General Data Protection Regulation identifies a EU citizen who is providing their personal data, a data subject. So you would collect that consent from that data subject by having them do an active thing, and I guess we'll get into this later, won't we, Eric?
Yeah, we're going to give examples how companies can collect consent.
Exactly, but it can't just be a pre-tick box or an opt-out situation. They've got to actually opt in to get this consent. And then once you have it right here about at 5 or 6, anytime you want to process that personal data, and by process, I mean, why don't we go down to the third slide there, Eric? Because it looks like I've actually, right. So it is a cycle, but now Now we're to querying the consent. As you use this personal information, whether it's to build white lists for email messages, whether it's to come up with ad campaigns, or any of these other cool things that Eric told me about that you guys do with this personal data, you're going to want to make sure that you're honoring your customers' choices with respect to their privacy. And that means each and every time you're going to want to make sure that they have given that consent, and that consent is up to date, because if we go to the next slide, these data subjects, these customers, should have the ability to exercise their rights, that is to revoke their consent for processing. Just give me the next slide, Eric.
Yep.
And that could include suspending their consent for you to process their personal information, maybe asking for a copy of all the personal information that you and your organization have collected on them, or even exercising the right to be forgotten, just telling you that they want you to delete everything you know about them within reason. There is caveats for, of course, you're not going to delete someone's credit card information before they've paid you, obviously. In that case, it is in your organization's legitimate interest to hold that data. And so there's a little bit of thinking and policy that goes into how you empower your customers, your data subjects to exercise their rights, including revoking consent, which, as I mentioned, that's the next slide. That would be exercising the right to be forgotten, in which case, if they come back and complete the cycle and want to use your product or service again, they're going to have to provide, they're going to have to get consent again and look at your notice again. So as I pointed out, it is a cycle that goes around, and it starts with a privacy notice that has a number of requirements that are baked into several articles of the GDPR. You see a lot of articles 12, 13, and 14 in here, maybe a little bit on Article 22 about automated processing. That would be revolving around customer profiling and maybe tracking them from website to website. But luckily, what is required in a privacy notice to invite a customer to provide their personal information breaks down into a number of chunks that are pretty easy to understand. So if we go to the next slide here, Eric.
I think we're talking about we have to get consent here.
Oh, okay. I'm sorry.
We have other chunks here.
So big chunks. Of course, you want to provide the legal basis that the data is being provided under. There are 6 legal bases within the GDPR. Consent is just one of these 6. So basically just say you're getting consent to process this personal data.
And for most publishers, with what we do, we're going to have to get consent. If we're going to give them, we're going to send them newsletters, or if we're going to do lead generation, or if we're going to do other stuff with it.
Any processing or direct marketing, you specifically need consent.
Right.
But as I pointed out, with like holding on to financial data that you could hold under the basis of legitimate interests, I mentioned. Of course, a notice needs to tell the data subject who, what, where, when, how this data is used, who is, what if you share that data with someone? Where is the data stored? How long will you hold on to it? And of course, you need to tell the data subject their rights under the GDPR in a privacy notice. And there are a number of aspirational qualities that the GDPR wants you to put in your notice. If you look down at the last, in the right-hand column, Eric, probably around explicit, specific, informed, concise, transparent, intelligible. Those are particularly Weasley requirements of the GDPR, which we could easily create a whole nother webinar about at another time. So
I think the key thing here is that look, as media companies, we already have privacy policies on our websites, or if you don't, please get one. You're already at big risk.
Right.
But you're going to need to go back and look at your privacy policy. Hopefully your privacy policy not only addresses CAN spam, but also addresses CASL, the Canadian anti-spam law, also addresses the California privacy requirements, and now you want to make sure your privacy policy also addresses the GDPR requirements. And most of the same requirements, most requirements are going to be very, very similar. GDPR is just going to add a few more little things to it. So again, just make sure your privacy policy hits these points.
All right.
Okay.
So we did talk about perhaps giving consent and what that means to a data subject, a customer. Explicit consent is when the data subject any freely given, informed, unambiguous indication of the data subject's wishes by which he or she, by statement of clear affirmative action, signifies agreement to the processing of personal data relating to him or her. That's a mouthful. And what that comes to mean is that the customer, the data subject, must actually have an action that they do that indicates that they're comfortable with giving their consent, whether that's checking a box that says they agree, or actually the physical act of entering their personal data, so long as the privacy notice is set up to make sure the data subject knows that that indicates they're giving their consent. That could be it, but no pre-ticked boxes, no opt-outs. They really want to see some sort of positive engagement by the user of your software or process to make sure that they have given their consent. And then you want to record that consent.
Yeah, so in this case, with publishers, whenever you're collecting personal data, right, getting back to the screen here on your touch points, whenever you're collecting personal data, you've got to make sure that you are getting consent to collect that personal data on it. So it's not just a form, but you have to actually have the notice and you have to collect the data. And were you done with this slide, Andrew? You want to go on and show some examples?
Yeah, let's do that.
All right. So Andrew and I we looked at a few things to put together some examples. So Electronic Design is a pretty sizable magazine underneath Penalties, which is now part of Informa. So let me take you out to their site for a second, show you some stuff that they're doing here. So on the site, they have a register over here. Now, I don't know that they've set this up for GDPR yet, but they're doing a pretty good job. You notice right here, whenever you go to sign up, they've got a disclaimer here. And let me blow that up just a little bit here so we can see what it looks like. So there's a disclaimer that comes up. It says, hey, by clicking, I'm acknowledging the terms of service, and there's a link to the privacy policy. It's all right there. Now, by the way, you do not have to have this check, sign me up for electronic design newsletter. You don't have to have that. You don't have to have that box. Someone could just fill out the information, and then you could have this statement here, and then you could click register. Right. You've given notice, and this also, by the way, is what you need to do for CASL compliance as well. You've got your full privacy policy there, and the simple act of registering is what Penton is using for consent, positive consent.
And now, that checkbox might be because there are other newsletters that they have for other users. That could be what's going on there.
Yeah, there could be another reason
it's like a granular bit of consent that they're saying, I want the Electronic Design Today newsletter, but don't send me email about, I don't know, something else.
Right. So anyway, this is one example where, hey, just this simple statement here with the link to the privacy. Now, this is not, is this going to be considered consent and from the eyes of GDPR, positive consent? Nobody really knows for sure. This is one example. I'll give you one other example here of what Wall Street Journal is doing. Now, Wall Street Journal is part of News Corp. big giant company, big bullseye on their head. If you go here, this is their newsletter sign up. And let's say I want to sign up for this newsletter. You notice right here, I already understand I'm going to get this, and I agree to the privacy and cookie policy. You've got to check this to even be able to sign up. This is a little tighter consent. Now it's not just saying, not just the fact that you signed up, but the fact you actually checked the box to this. Your business will have to measure what you think your tolerance for risk is. I mean, the Penton example, it could qualify just fine. We don't know until that comes up here. I'm going to give a couple other quick examples here. Let's look at Local Marketing Institute, what they're doing. Here's a landing page, and you can see on the landing page, same thing here. By submitting this, you understand what's going on and you consent. They don't use actual words consent, so I'd say we should change this to actually include the word that you consent to, to disclosing your personal information to this company. But again, here's another example where you don't necessarily have to have an affirmative checkbox like you do with Wall Street Journal. PrivacyCheq. Let me show what you guys are doing here. So I brought this up, and do you want to talk quickly about what you guys are doing here, Andrew? This is taking consent to the nth degree and
this
making 100% lock solid that you got consent.
Right, but this is our job. So we're also showing off our software, and as you can see, this is a contact page. We're not even going to let a data subject or a customer enter their name or their email address until they've clicked on this view and consent button. And then we actually are asking the data subject, the customer, to give their consent right on the privacy notice. So we can prove that, in fact, the notice was shown. We're saving the version of the notice that was shown, and the data subject's going to give their consent, identify themselves, and that email will just fall right into the next form, and then they can continue along their way.
Right. So this is obviously, that's very intrusive, but
very.
PrivacyCheq, obviously, this is their whole business. So they're showing, hey, if you really want to do compliance to the nth degree, we're actually, before they can even fill out the form, we're going to show them the privacy policy. We're going to ask for their consent, and then we're going to store that on our system. And now you can access the form. So this is everything from, this is probably the least stringent up to what PrivacyCheq is doing, which is the most stringent. So again, we want to show you some different examples. We can't really tell you what the best way to do is on that. That's up to you. I think the most important thing, though, is silence or inactivity. Implied consent is, doesn't hack it anymore. You've got to actually get consent, and you cannot use pre-checked boxes. There was a question that came through that said, could we please step back and succinctly explain what GDPR is? Okay, I thought we had done that at the beginning, but let's go back and do that one more time here. So again, GDPR, the European Union's General Data Protection Regulation, is designed to protect consumers' digital data. And bottom line, it's a set of regulations that says before you collect any personally identifiable information, you must provide them with notice of the data you're collecting and what you're going to do with it. You must get consent from people to collect that data before you collect it. When you get ready to use it, you have to make sure that you are complying with the consent you have collected. And then we're going to get to the place here in a minute where you have to say, you also then have to allow people to exercise certain rights regarding their data. That is what GDPR is, and it goes and it's already on the books right now. The enforcement is going to begin on May 28th. Hopefully that helped answer the question as far as the succinct explanation of what GDPR is. If not, please drop me a question or a chat. That would be fantastic. So we gave you some examples of, we talked about that you have to provide notice, your privacy policy, and you have to put that notice right there in front of someone before you collect the data. And these are the things that your privacy policy must comply with. We talked about consent, that you have to get the consent. It has to be given. And we gave you some examples of ways other companies are collecting consent, whether it's just a notification right there in the sign up with a link to your privacy policy, or whether it's something like News Corp is doing, where you actually have to check a box to say you agree to it, or at the extreme level, what you're doing with PrivacyCheq, where they actually, before you can even access a form, they're showing you the privacy policy, they're collecting your consent, and then you have access to the form. That's at the one. So there are different ways companies are going about it. You have to choose what you think is the right way to do for yours. All of those could technically be considered, but it's all levels of risk. I hate legal stuff because it's never black and white. It's always shades of gray.
And we can't say it enough. Eric and I are not lawyers, if that isn't obvious yet.
we're trying to make sure, give you the parameters to make sure you can navigate this with your company. Right. Let's talk about then the rights. So this is the next step, right? You provided consent, you got consent. Now let's talk about the customer rights. What does GDPR give to the individuals as far as their rights, Andrew?
Right. There are a number of rights that are required by the GDPR. These rights should be enumerated in the privacy notice, and specifically they are what you see here on the screen. Automation is not necessarily required to carry out these tasks. I should probably point that out at this point, that if you just feel comfortable pointing your customers towards, say, an email address or a support phone number, a lot of these rights could be provided by a human being within 30 days of the rights request.
Good point. Let's talk through a few of these here. So the right to access.
Okay, yeah, I'm sorry. Right, the right to access would be if a data subject asked for a copy of the personal data that had been collected by them. Of course, the right to rectification would be if some of that data might be wrong, that they have the ability to fix that. Those two could be covered by a customer portal if you already have one. The right to be forgotten, Article 17 covers giving data subjects, your customers, the ability just to be forgotten, ask you to delete all their personal data they might have on them. The right to restrict processing is a little different from the right to be forgotten, but it's more or less the same thing. This would be the case where a customer might ask that you suspend processing, but they don't necessarily ask that you forget them. And in 9 cases out of 10, there isn't much value to having that data if you can't use it, so you end up just deleting them anyway. But there are cases where a customer might ask that, or depending on your basis of processing, you might be able to get away with that. Of course, then we get to data portability, which we're not quite sure what that's going to be because there's no code of conduct based around how you would give your personal data, to a competitor or another organization. But essentially, that is the right to take the personal data from one vendor and share it with another. Of course, the right to object to direct marketing, that's the article that says that you have to get consent to send emails and marketing messages. Number 22 would be automated processing. That revolves around profiling and maybe tracking data subjects from website to website. And finally, the notification obligations are pointed at letting a customer know once these rights have been honored, letting them know that they're in fact all their personal data has been deleted, or that their personal data has been rectified.
So the beautiful thing about this is that these regulations are written by bureaucrats.
Right.
And they just know, hey, we want customers to be able to do this, and this, and they don't
every
really
language of
understand.
the EU too, I might point out. So that could even be different from jurisdiction to jurisdiction.
Correct. And so they don't really necessarily know what that means and how companies are actually going to implement this. They're just saying, look, you got to do this, and it's up to us to figure it out. So this is going to be developed over time. Let's talk a little bit about kind of practically what this means for customers. So number one, you've got to track and store the consent that you get and the requests that you get for these rights. So you've got to be able to track and store consent. How do you do that? Okay, that could be everything from like Andrew was saying. It could just be, hey, send us an email, and you're tracking consent and requests in a spreadsheet. I think you were talking about something like Microsoft is your biggest competitor, Andrew.
Exactly, because a lot of organizations just keep this information in PowerPoint, or not PowerPoint, Microsoft Word or something.
Yep. So, I mean, on the low end, hey, you just provide an email address. When someone gives you consent, you store that in your email system or your unified audience database. And then if someone makes a request for the consent, you manually, another email goes to a person, they manually do all this stuff. On the other end of the spectrum, you could develop a system yourself on how to do this. There are some companies who are developing their systems themselves. And then on the other end, there are dedicated companies like PrivacyCheq who develop systems to help you, like you saw us demo earlier, to help you collect and manage that consent. So sometimes those systems have a whole kind of dashboards in the back end to manage consent and who's given the consent and who hasn't given consent and all that kind of stuff. So, but either way, you as the publisher are responsible for one, presenting the presenting the notice, providing the notice at the point of collection.
Right.
You are responsible for collecting the consent. You are responsible for storing their consent. You are responsible for having a way for individuals to make these requests, right? They have the right to ask to see all the data you have about them. Okay, so they have to be able to request that from you. They have to be able to request the ability to correct any incorrect information. They have to be able to request to be completely forgotten in your system. All these various kinds of things, you have to provide that ability. If that's a system or if that's an email and a person, that's up to you. But you also then have to develop processes to honor those requests, right? So you got to think about, all right, if someone asks us to give them all the personal data we've collected to them, how are we going to do that? How are we going to do that?
Where is all that data in your organization?
Right. First of all, where is all that data? And if someone asks for it, how are we going to do that? If someone asks to make changes to data they think is incorrect, how are they going to request that, and how are you going to do it? If someone asks to be forgotten, hey, I want you to be completely removed from your systems, how are you going to do that? How are you going to remove someone from your systems? This is especially tough if you got or
maybe you can anonymize them. That's an option too. It's all going to depend on your comfort with risk and what your particular organization is doing.
Yeah, exactly. But like in this case here, I'm working with some e-commerce companies who are going, well, we have a record of this transaction purchase. We don't want to delete the transaction from our records. How do we do this? Well, what they've decided to do is, okay, they're going to keep the transaction, but they're going to go in and anonymize, right? They're going to get rid of the person's name and email address and phone number and physical address, but they're going to keep the transaction so it doesn't screw up all their financial reporting. How are you going to then notify customers that you have fulfilled their request? Again, you could do that manually. That's what kind of I think does PrivacyCheq do something like that, Andrew, as well? Notify the customers.
Indeed, yes.
Okay. So or you can use an automated system, or you could build something yourself. I do want to share, this is all like, oh my gosh, what a royal pain in the rear end. This is the reality. It is a pain in the rear end. This is the reality of where we're living. The U.S. privacy regulations are eventually probably going to come up to the same level as the EU. They're going to have to. The good news is you've already got a lot of these processes, right? You've got the processes for direct marketing opt-outs already built in. So, this is your email and text messaging opt-outs. So you've got a lot of this already built in. You just have to build upon it. Is there anything else you want to add here, Andrew? But we're getting close to the end here. I want to kind of wrap this up and answer any questions that we may have out there.
Yeah, I think we are. Just know that everyone in the EU is dealing with this, including governments and medical staff. If someone wants to be forgotten, do you delete all their medical records too? There are all sorts of questions.
Right. So look, I know that the most frustrating thing that I ever dealing with our legal counsel at HarperCollins was I could never get just a pure black and white answer. Tell me what to do. And I know that as media companies, that's really what we want. Again, these regulations, who knows how well they're going to be enforced? Who knows what the interpretation of all of them is going to be? There is no hard and fast answers right now, and I know that sucks. But what I want to do is say, hey, can I boil this down to some basic takeaways for you guys? All right, number one, here's the basic takeaways I'd recommend for you. Go back, re-examine, and update your privacy policy. Make sure your privacy policy is taking into account all of these provisions. As long as your privacy policy is doing that, all right, you've done that piece. Implement a way to gather and track consent. All right. Everywhere you have a customer touch point where you are collecting customer data, implement, give that notification. Let them know right at the point where they're going to click submit, hey, this is what you are consenting to. Here's a link to our privacy policy. And by submitting this information, you are consenting to this. Or use a checkbox so you can say consent, or go as far as what PrivacyCheq does with their own website where, hey, before you can even fill out the form, you got to consent. You choose the strength of consent that you want to get from people, but make sure you're presenting that consent and that you're gathering that consent. And make sure you're storing that somewhere so you have record of that consent. I don't care if it's just in your email database, there's this extra field. I don't care if it's a separate system that you're building. I don't care if it's using a system like PrivacyCheq. Implement a way to gather and track that consent. Also implement a way for people to make those, to request their rights, that they have to request rectification, to fix their data, to see their data, for you to forget them. Implement a way for people to request that data from you and track those requests, and then have processes in place to honor those requests. Figure out, hey, how are we going to give someone a copy of their data? It doesn't have to be one file. It could be multiple files. It doesn't have to be easily readable. It could just be a database dump. There's nothing in the law that says what that has to look like.
Right.
Give them the ability to correct incorrect data, figure out a process for that, figure out a process for them to revoke their consent. It could be just as simple as opt out. I'm going to opt out, and when you opt out, you're now my blacklist. And revoking consent isn't necessarily forgetting, but also then have a process in place to remove all personal data about a person from your systems. So every media company is going to be a little bit different. You're going to have different levels of risk. You're going to have different systems. You're going to have different things that you do. What we wanted to try to do was give you some ideas as to what the law required and some examples of what some other folks are doing. And now you got to take this and run with it. And again, in May, is the sky going to fall? No, but your risk is going to go up then. And so find some ways to mitigate that risk. And by the way, if you are compliant with GDPR, good news, you're going to be compliant with CAN-SPAM, you're going to be compliant with CASL, and you're going to be compliant with the California privacy regulations too. So it's setting the bar of a new standard, and this is just a price of doing business now if you're going to be a media company in 2018 and beyond. So if there's any questions, I'm not seeing any questions coming through. I'll give you a couple minutes here to throw any questions through to Andrew or to me. You can use the questions, or I don't think they can chat directly if they can. But I'm not seeing any questions coming through. So if there's no other questions at this point, feel free to reach out to either Andrew or myself. We're happy to give you some thoughts or ideas. And in the meantime, I hope you guys have a fantastic rest of the week. Tim, I'm going to turn it back. Oh, wait, we do have one question come in here. If a purely U.S. business happens to have a European user visitor on their site or subscriber for marketing communications, does the GDPR still affect that? Okay, yeah, we did cover that. And bottom line is, if you have any European customers, email subscribers, website visitors, or app users, you're subject to GDPR. Now, what's your risk level? We also covered that as well. So if you happen to miss that part of the presentation, I think, Todd, are you going to make this available to your members?
Yes, we are.
Or Tim? Okay.
Yes, we are. And we do have a couple questions here, so I'll make sure to send those along to you.
Yeah, well, if you have those questions and want to throw them out, I've got a few minutes.
All right. They'll be down in your chat in the bottom right there for you.
Okay.
Actually, the second question here, maybe I'll take this one if I could, Eric. From a business perspective, there's an interest in making the consent process as unintrusive as possible. Exactly. You want to kind of lower the friction to nothing, don't you? Do you have a point of view on which of those consent approaches meets a minimum acceptable standard? I certainly have a point of view on that, but I'll say it again. I'm not a lawyer. It could be as easy as the PECR law on the Irish Times that Eric showed, where maybe you come to a website or a mobile app, and you're immediately offered a link to a privacy notice, and then there's just a button that says, I consent. In this case, Article 11 of the GDPR says that you can actually get consent for processing without even having a full knowledge about who it is that's giving that consent. And of course, then to manage their choices later, they would have to identify themselves to do that. So it could be as simple as one click right as things get started before anything happens, or it could be as complex as what Eric showed you on the PrivacyCheq site, where a big Death Star pops up and takes control of the screen.
Yeah, I was going to go back here, and so like I'm a media person. I've been in media of my entire career. I've learned, unfortunately, more about privacy law than I ever wanted to know, but I've had to do it. Honestly, it could be something. I mean, from my perspective, I'm also looking for the minimal friction. Right. Something like this, where you're putting out your consent, and you may want to change the wording a little bit. But you're saying right there at the point of collecting data, you're telling people that, hey, who you're giving that they're giving their data to this person, that they consent to give the data, and there's a link to the privacy policy right there if they want more information. I am going to be implementing this with my clients that I work with, but you and your legal counsel, I know if I was at News Corp, they may say, no, we want to go this level because this is what our legal counsel feels is the minimal acceptable standard. So there is no minimal acceptable standard as defined underneath the law. I just wanted to throw that out though. So again, I'm looking for minimal friction as well. The form that's displayed for electronic design, you're right. It said it had a default country of the United States. You are absolutely correct. And yes, you're correct that underneath CASL, you cannot pre-check. And you are absolutely correct. If you go back and you change Canada, boom. Oh, I guess it still does keep the pre-check box. But, oh, no, it didn't have it here. See, it unchecked this. So if we go, let's go back to the United States.
It was the optional one that's pre-checked. Yep.
See, this down here, this is not there. Penton/Informa's interpretation of the law is all right, if they're United States, we can just show them this, and then if they register, that's good enough for consent. They believe that for Canada, someone actually has to check the box to be able to register. That's up to interpretation. Certainly this is more stringent, but there are other places here where there's other schools of thought that, again, this is enough to say consent. There's no checkbox here. You are basically saying, look, you have to fill out something and you have to take an action, and that by the submitting that action, that is considered consent. So again, this is where there's gray. Would a court of law consider this to be affirmative enough consent, or would they consider electronic design to be affirmative consent, or do they consider Wall Street Journal to be enough to be affirmative consent? No one knows. No one knows. This is the least friction. This is a little more friction. This is a little more friction. So the more airtight you want to make it, the more friction you're going to have. You have to weigh those risks.
There's another question here I'm going to take. Eric, if I could, is the penalty 4% of a company's global revenue or just EU-based revenue? It is the global revenue of the company, for what it's worth.
There you go.
Then there's another question.
Another question, is it product or company-based approval? It is right. Company-based consent. So very similar to that. This is an interesting question. If you have someone's zip code, can you assume they're an American customer? Is that enough without explicitly asking them? Good question. What do you think, Andrew, on that one?
Well, my answer there is that no, it's not, because there are a lot of Europeans who might live in the United States. The only you can't even do it by IP address. You actually have to ask the data subject where they are in order to do some sort of gating, just like you demonstrated.
Yep. Another question is dual authentication required for content access more than email plus password. I'm not sure what that question means.
Would that be double opt-in? Is that what?
Yeah, I don't know what that question really means. So maybe if someone who asked that question could chip in a little bit more and explain what you mean, that would be good. But
or perhaps exercise your rights after the fact. That
maybe. You know what? I'll tell you what we'll do. It's past 11, and I know that we've got some other things that have to go, and we want to certainly get the questions. If you have additional questions, why don't you pass them along to MCMA? We'll try to get those, and Andrew and I will try to answer those offline via email. And again, you can always feel free to reach out to either Andrew or me, and we're more than happy to help with whatever questions you may have.
Right. So thank you so much for your help, Tim.
Great. Thank you so much, Eric and Andrew. And we really appreciate everybody coming to this January webinar, which was extremely informative. Like Eric and Andrew said, if you have questions, feel free to send those in, and we'll make sure to get those answered for you. Eric and Andrew, thanks so much. Thank you to our sponsors. Obviously, we could not do this without you. Make sure that you check out the website for upcoming events. And other than that, thank you so much for everybody for coming. Once again, Andrew and Eric, thanks so much, and we appreciate your time. Thanks so much, guys. Have a great day.
Have a great day.
Bye.